Again. Following program may be pre-recorded.
The Word on Wealth with Gary Quackenbush is sponsored by the Word on Wealth Radio Network. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now, here's Gary
live. Hey, everybody. Happy Tuesday. Welcome to The Word on Wealth. This is Gary Quackenbush sitting in front of, oh my goodness, one of my most favorite places in Yosemite. I love having pictures on my background. I'm sorry. You can only see that if you're watching on YouTube, which this show is live streamed. So we are live on the air, live on the stream, live on the internet. We are live. Do you know that the government is going to be shut down? It's so fun to hear stuff like that. I was talking to my associate on Monday about the government shutdown because we'd heard the news, right before. If the government can't come up with an agreement, it's going to be shut down. And most people say, no, it's never going to be shut down. It'll never happen. Well, I have right here in my drawer, if I pull out, I have this tape and I actually recorded it. And it was way back a while ago. And it was really interesting because I was calling the IRS on a case that I was working on. And it said, you have reached the Internal Revenue Service. The federal government is closed. Check your local media outlets to see when the government about the reopening of the federal government. Yeah, so I actually kept this little tape right here. It's so funny. But so yeah, it does happen, and they literally shut down the government. And it was in I have it right here. I should play it. I gotta figure out how to do it. It was in 1996, but it was a while ago. It really did happen. And we think our money problems are bad now because we can't balance the budget. This was 1996, you guys. It was a long time ago. This happens like every year. They just can't figure out how to balance the budget. And then they send out trillions of dollars and they expect us to just kind of like pay more taxes and beat up the guys that are working really hard and making money and make them pay all the taxes. But whatever, it is the most organized government in the world, which is a good thing and terrifying all at the same time. Well, that's Gary's news for the day. See, I'm not a news head because I don't like to be influenced by it. But when it talks about the government shutdown, it always kind of makes me think, gosh, I remember that day when I called the IRS and it said, the IRS is closed. Due to the government shutdown, the IRS is closed. Please, follow your news channels for the reopening of the federal government. Beep. And couldn't get any business done at the time. So it really does happen. Well, in other news having to do with my career, and that is estate planning, wills, trust, power of attorneys, trust administration, etc., there was a news story that came out, updated on December 9th, and it talks about a woman named Cathy Areu. She is a former reoccurring guest on the Fox News shows, and she was known as the liberal Sherpa. And she was out there on Fox News talking about, all the whatever news. She's this journalist and all that. Well, now, apparently, Miss Areu, 51 years old, in Miami, Florida, was booked into a Miami jail because of a host of felonies, including kidnapping, elderly exploitation, and organized scheme to defraud. The wild thing about this story is this is stuff where you think that doesn't happen to regular people. Just doesn't happen. This is stuff you see in movies and crime shows and all that. Ladies and gentlemen, boys and girls, this is true stuff. What had happened, and I haven't read like really detailed in this, but I've read the story on what happened. And basically what's happening is Cathy was in charge of her mom's money. She was the successor trustee. Mom had dementia, didn't really know what was going on. And so basically the accusations, and they're not always true. They're not always provable. Sometimes it's really difficult to prove. But what she was been arrested for is elder exploitation, which means that they have evidence that her mom was put into like a facility that she didn't really need to be in, but she was put there because she was feeble enough where she couldn't get back out. So that's her daughter left her. And then you can look at the records and all the bank accounts and see how her lavish spending was going on while mom was stuck in this facility. and I guess Cathy was claiming that she needed to be there and it was necessary for her health and safety, and and it was affordable. Well, then Cathy's going out and spending her money. So I mean, there's just a lot of stuff. So that's why they call it kidnapping, elder exploitation, organized scheme to defraud. It's kind of this big plan. Things like that are frustrating to me. So as an estate planning show and an estate planning attorney, let's talk about this situation. Let's break it down a little bit. Like, how in the heck do you prevent that? Because isn't that scary? How many of you have thought about that? Like, well, what if I put my kid in as my successor trustee, and then I become really feeble and maybe have dementia and maybe I'm annoying, or I put the dirty dishes back in the cabinets, or I smell bad and now I get stuffed away in some facility somewhere by my child who's decided that I'm a threat to myself. And then I think, well, wait a minute, I'm not a threat to myself. I'm a threat to your inheritance. And that's why you've put me in this facility. So those are the things to take thought of. When I talk to people most every day about their wills and trusts, well, for sure every day about wills and trusts, but trust administration, usually that's, 5 times a week that I have new cases on that. But we're looking at a situation where we're trying to figure out who should be my successor trustee. Well, if you look at this case, well, we certainly don't want Cathy Areu to be my successor trustee, because even if she is my beloved daughter, it came out that apparently she wasn't as beloved as I anticipated. How do you prevent that? Well, number one is don't feel compelled to put your children in as successor trustees. If you believe they're going to treat you right, if you got a great relationship with them, if they're doing, financially well on their own and they don't even need your money, that's probably the best idea. If you get a financially dependent beneficiary, maybe somebody that, that is with you a lot and they're financially dependent on you, and now you're, and they really aren't super good at working, and maybe they're not good at making money, and maybe they're a little moochy, that's probably not the one you want to put as in charge of your trust, because if you become incapacitated, then are they going to make the decisions
2 minutes.
in your best interest? Like, are they going to decide to put you in a facility because you're out of the way and now they can spend your money? Or are they going to get greedy? Are they going to get a little stingy? Like, ooh, I don't want to spend that much money on mom, because every dollar we spend on mom is less money that I get in my inheritance. And sometimes it's not the actual them thinking that, but it's in the back of their mind, and you don't want that. So I can help with this, help you make these decisions. I talk to people about, how to, who should be your successor trustee. Give me a call at 855-500-TRUST, 855-500-TRUST. And when we're putting together your estate plan, your will, and your trust and all that stuff, we'll talk about how to choose a successor trustee. You just want somebody that you can trust, you feel good about. If it's your kids, great. If you're not sure which one would be the best, you can put them in as co-trustees. I'm not a huge fan of that, but if you don't have any other choice and you're trying to figure out whether the kids are going to work well together or they're going to work to take care of you together, then you probably want the kid that loves you the most and that would care about you and do anything for you. And maybe you can have them together as co-trustees, which, like I said, that's one of those things where it makes it a little more difficult for them during the trust administration process. Sometimes it makes it a lot more difficult, but maybe that's what you need to do to care. So watch out for yourself when you choose a successor trustee. You can avoid the Cathy Areu situation where mom gets put away in a facility where she doesn't even need to be. And the thing is, and I'm not making this stuff up, the evidence was, they talked to people at the facilities that said, yeah, her mom didn't need to be in here. She could be on her own and she was totally fine. She was just kind of being left, kind of dumped, which is really sad. Okay. If your mom raises you, takes care of you, shame on you if you're going to do something bad to her. That's just bad news. So it happens once in a while, but it's the news. And the reason it is news is because it is news. If this was an everyday occurrence, that would be horrible, but it's news. I'd be able to help you out with your trust administration process. Give me a call at 855-500-TRUST. Coming up next on the show, we're going to talk about mom managing the family business right here on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com. You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com. Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, your team at GQ Law are experts at solving IRS and state tax problems. Talk about that.
When people have a tax problem, it tends to really stress them out. And one of the things we've been able to do is figure out how to resolve tax problems. One thing we might be doing is setting up a payment plan or getting a collection delay, maybe getting a determination that the person shouldn't have to pay the taxes at all. We do offers and compromise. We do audit reconsiderations. And one of the things that's a really powerful tool that some people don't recognize is sometimes bankruptcy can be used to actually eliminate taxes when there's certain conditions of the code that are met. So we can do all kinds of things. After we analyze your situation, we can figure out what's available, discuss your options, and figure out which ones to implement, what it's going to cost, how long it's going to take. And we can get people out from under all kinds of tax problems so they can sleep again. That's our goal.
Request your free initial consultation. GQlaw.com. 855-500-TRUST. GQlaw.com.
You're not alone. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST. Or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's GQlaw.com, 855-TRUST.
You're live.
Hey, good to be back with you here on the Word on Wealth. This is Gary Quackenbush. What if mom no longer wants to manage the family business? Wow. How could that be? Mom always wants to do everything. In this situation, it would be mom and dad run a business. It's kind of dad's thing. Mom's helping out, especially towards kind of the end as dad's getting older and more tired, and mom can kind of keep up. So they kind of join forces sometimes. Dad passes away and now mom is running the family business and just kind of getting tired. What if she doesn't want to manage the family business anymore? Good question. Well, you could do a number of different things. One is you could create a power of attorney. And so let's say that you have a couple of kids, two of your kids decide they don't mind running the family business and they'd like to do that. But you don't want to give them the business yet because you like the income from it, but you're getting tired of running it. And you want to make sure they can do it if you decided to stop or if you died or something happened, became incapacitated or whatever. So the first thing you could do is give them a power of attorney. I would do a specific power of attorney that would allow one or two children and maybe in succession, like this one first and this one if the other one couldn't do it. And I would give them a power of attorney that would let them run the business affairs, get into the bank account, make contracts, transfer things, and basically take over the business with a power of attorney. Now that'll work while you're alive. When you pass away, power of attorneys don't work anymore. So while you're alive, a power of attorney could work. So that would be mom running the business, gives authority to her sons, for example, that they could run the business with a power of attorney. Okay. The other way is make sure that family business is in that living trust. And if it is, now we know that the successor trustee is going to be able to run the business. Okay. So then mom resigns as trustee of the trust, and who's in charge? The successor. That would be one of the kids. So one of the kids that's named as a successor trustee now serves as trustee. So as trustee, while mom is still alive, whether she's incapacitated or not, as trustee, they would have authority then to start managing the business. Okay. When mom died, they still have that authority and that ability. Okay. That's different than a power of attorney. Because if you did it with just a power of attorney and mom died, the power of attorney goes, poof, it's gone. It doesn't work anymore. Bank can't take it. If you go to a power of attorney, to go to a bank with a power of attorney and you know that your mom's passed away, that's actually, they call that illegal. Not supposed to do that. Power of attorneys go away at death. So if they're durable, they work during disability and incapacity, but not death. As a trustee, though, if the business is in a trust, then that successor trustee child can actually take over and run the business as the successor trustee. Okay, so then that's the question, like if mom wants to resign, well, how do you do that? Well, it's done officially. It's not where she just says, I'm done, I'm out of here, I'm going home. You do something official, meaning you would create a document that would say that, I, mom, trustee of the mom and dad trust, resign as trustee in favor of my son, John, who will serve as successor trustee. And he will be the one that's already named in the trust. So she's stepping out of the way in favor of the person that is already named as the next successor trustee. So then she signs it in front of a notary and he signs it in front of the same notary. That's the best way to do it. If it's not notarized, it's okay, but it's not the best because you might have a bank that says, nope, got to be notarized. So she resigns. John picks up the post as successor trustee, and now John can manage the business and the family affairs. Pretty cool, right? That's how you resign. Okay, what if, though, what if you're thinking this would be a great idea, but you have no idea how to put the business into a living trust? Now, this is something I'm going to explain, and if you do want help doing it because you have maybe you have a limited liability company like an LLC, or maybe you have a corporation, and whether it's a C corporation or an S corporation or a statutory close corporation or a limited liability partnership, any of those, how do you put that in the trust? Because if it's in the trust, then we know that trust the trustee can manage the property and the thing that's in there. Okay, if it's a corporation, we take the corporate stock, and instead of it being issued to you as an individual, you turn in your corporate stock to the corporation, and the corporation reissues stock to the trustee of your living trust. Got it. Okay. So the stock is now, if I looked at the stock certificate, it's going to say, mom, trustee of the mom and dad trust, are the owners of 1 million shares of stock in this company. So that shows that the trustees are the owner. That way, when mom steps aside, dad's already died. When mom steps aside or dies, that stock is held now in that trust. That means the successor trustee is in charge of it. That means the successor trustee can run the business, can do his thing, can make it so that business doesn't just fall apart and have all the competitors come and consume its flesh. Okay. You're going to be able to operate it. What about an LLC? If you have an LLC and it was properly created, keyword there, you will be holding a membership interest certificate. It's a certificate that looks just like a stock certificate, but it doesn't say stock. It says membership or membership interest. That certificate would then be in your name. So it would be like Gary owns, 55,000 membership interests in such and such a company. Okay. You turn that money, you turn that membership interest certificate back into the LLC. The LLC then reissues it, same number of shares, to mom and dad, trustees of mom and dad's trust. So now the LLC membership interests, but if I look at that certificate, I can read it and it says trustee of mom and dad's trust. So I know who owns that company. If you have an LLC and you did not get membership interest certificates, or if you created a corporation and you didn't get stock certificates, you didn't finish the corporation, you didn't finish the formation of the LLC, because you have to have those, or else how do we know that you own it? That's the stock certificate thing. If you don't have a stock certificate, I mean, that. If how do you prove that you own part of like Apple? Well, you show that you electronically have a stock certificate. How do I show that I own GQ Law Corporation? Well, I have a stock certificate, but guess what? It doesn't say Gary Quackenbush. It says Gary Quackenbush, successor or trustee of the Gary Joe Quackenbush family trust dated 2001. Okay. So even my GQ Law Corporation is owned by my trust, because that's the way it's supposed to be. That way, something happens to me, I become incapacitated or I die, then my wife, who's my, other trustee person, she can then get an attorney to wind it down and sell it before it gets destroyed, right? Before it gets eaten by the competition. So that's important. If it hasn't been done, call me, 855-500-TRUST. Let's figure out why it wasn't done. I don't care why it wasn't done. If it's not done, it's not done right. So 855-500-TRUST. We'll figure out how to get your LLC into your trust, your corporation into your trust. What if you have a sole proprietorship? Super common, right? John's Cabinet Building Company. Well, John's Cabinet Building Company, there's no stock certificates. There's no membership interest certificates. How do we know it's owned? Well, it's got his name on it. So what we do is we do a bill of sale. We sell the company to the trustee of the trust. So we basically are selling the company to the trust. We have a bill of sale. And that way the trustee says, see, right here, I got this piece of paper and it says it was transferred to me as the trustee of this trust. So it's a bill of sale. So we sell the business to the trust. And so all those transactions are tax neutral. It does not change, when you move a business or move a house or a bank account, it does not change the tax basis, the taxable basis, the inherited, and none of that gets changed. It's transparent. So whatever you paid for the company, the trust still gets credit for the amount of money that you paid. Okay. So now we know how to how to transition the business from you to mom. From mom and dad to mom, and then mom to you guys. Okay. Or to your kids, however you got that structured. Okay. Now I want to compare the difference between a power of attorney and a successor trustee. What's the big difference between the two? Because I think it's good to know. Understanding this stuff is important, and I know you understand it. How does it apply to you? I'm happy to talk to you about that. 855-500-TRUST. We do it on a daily basis. You can call and get a free consultation. Get on my calendar. 855-500-TRUST. Power of attorney versus successor trustee. What's the big difference? Why use one over the other? I love successor trustees because that means you have a trust, and the successor trustee is managing property after the creators of the trust have died. That's why they're the successor. If it was the creators of the trust who are the trustees, they're the trustees. The successors are the ones that took over after the initial trustees died or became incapacitated. All right. That successor trustee has a fiduciary duty, just like Anthony Wright, our financial advisor on Thursdays, just like a guy that qualifies as a financial fiduciary and has this extra qualification that they are now a registered financial fiduciary. If you're serving as a successor trustee, you are a fiduciary. That means you're required by law to act in the best interest of the beneficiaries, not your best interest, the best interest of the beneficiaries. That doesn't mean you should do the biggest, hottest, most profitable business deal or stock transaction in history. That doesn't mean that. That maybe is not in the best interest of the beneficiaries. In fact, I will tell you it's not, because it's too risky. Because if you lose, that's a big deal. All right. As a power of attorney, It's not the same capacity. You're not a fiduciary. It's not created so that you act in the best interest of the person that gave you the power of attorney. The power of attorney gives you this carte blanche authority to do anything that it says you can do. So there isn't that same, fiduciary responsibility that you have as a successor trustee. Now, don't get me wrong. If you do something wrong, if you do something illegal, if you cause loss or damages, you can be sued for it. It just doesn't have that same level of responsibility and oversight as a trust does. See, if the successor trustee messes up, who's in trouble? Like, who gets damaged? Well, the beneficiaries do. That might be the creators of the trust. It might be the beneficiary children, but the beneficiaries are the ones that are getting harmed. So who's going to be the one that's watching that successor trustee do their job right? The beneficiaries. Who's going to be watching over the power of attorney? Nobody, because the power of attorney was given by the giver, right? And they may or may not be watching. So I would rather have everything in a trust and have the successor trustee in charge rather than a power of attorney. My personal opinion. I do like power of attorneys for certain limited purposes. They've got to be limited in scope. They shouldn't be general. And you got to be careful about the power and authority that you give to people. I'm going to talk to you about this stuff, and I'd love to have you keep listening to the show. If you want to talk to me offline about this, the number is 855-500-TRUST, 855-500-TRUST. What are we going to do next? Let's talk about a holographic will. And I've got a couple of questions I want to have answered, some questions that were submitted about, getting a house out of a trust. What about a Uniform Transfer to Minors Act? We're going to talk about that coming up on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST.
With SRN News, I'm Keith Peters reporting the new CEO of bankrupt cryptocurrency group FTX testifies before the House Financial Services Committee.
Sam Bankman-Fried was supposed to testify before he was arrested in the Bahamas. The Justice Department and the SEC say he deceived investors to enrich himself, bankrupting the company. New CEO John Ray told lawmakers it's an old crime, embezzlement applied to a new asset.
This is just taking money from customers and using it for your own purpose.
At its peak, FTX's market value topped $30 billion. Ray says in excess of $7 billion was lost and that there was no real record keeping.
They use QuickBooks, a multi-billion-dollar company using QuickBooks.
In interviews, Bankman-Fried denied any fraud. I'm Julie Walker.
On Wall Street, the Dow by 103 points. This is SRN News.
Broadcast outreach, the Word on Wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQ Law.
You're live. Hey, look at that. We are here live on the internet on, what are we on? YouTube today. So we're doing a live stream on YouTube. So you can watch this show. If you want to watch a radio show, which is kind of interesting, you could watch me talking on the radio. That's pretty cool. Couple of questions I want to get answered. First of all, what is a holographic will? A holographic will because I've had some people ask me that question, thinking that it was something that it's really not. But I had a guy that gave me like an email, and he said, here's an email. This was sent out by the person that died. He was sent out about 3 months before he died. And it says what he wants done with his stuff. Is that a will? I go, it's not a will. And there's no, I mean, does it show that there is, does it, have any indication that he had, testamentary capacity, or, is that really his email? Did somebody hack into his email? Was somebody else sitting at his computer? Those are the things that are difficult when you have a will that's not witnessed. Anything you have could show intention. It will help us determine what the deceased person's intentions or desires were, but those aren't wills. They might be, helpful, but it's not like a will. A holographic will is a will that's done by hand. Somebody wrote it all out. So they got out a pad of paper and wrote down, this is their will. And the will would have certain, there's like certain things that a will has to have to show that it really is a will. And it needs to show that the person recognizes that this is his will. Like if this is his declaration, his last will and testament. And it has to have language that's testamentary language, we call it, that is showing that on my death, do this. And then it's signed by the person without any other marks on it. So it's not written out by somebody and then signed by the testator, because then we don't know whether it's authentic. If the daughters are scratching all out this will, this I give all to my daughter because she's been with me for the last 6 months and she's amazing. It's really not what you're supposed to be doing. Because if then the daughter scratches out this will that changes the pattern of distribution, it's supposed to go to her and her 3 siblings, and now it's just all going to her, written by her hand, and mom signed it. That's going to be challenged. I mean, it's undue influence. She wrote it out. Mom couldn't even write. So you can't do stuff like that. That's why holographic wills, they need to be all in the person's handwriting, including the signature. That's holographic. We don't see them a lot. But they have to go to probate, and then we have to transcribe it, and then everybody gets to fight about it if it was a real one or not. So there you go. So then I had a question that came up, and this is the question that I'm in a group where people will submit questions, and they'll ask, how things work and try to get an answer. But what the question came out to be was, so the person asking it said, the property is in the living trust, but the title never got put in the name of the trust. How do we transfer it into a trust? And what I'm getting from the question is, this person is thinking that the property is, quote, in the living trust. Because when you get your trust document, there'll be the trust, and that's the thing that says who you are and who your trustee is, and then who gets money. And that document will actually usually have on the end of it what we call an Exhibit A. And the Exhibit A is an inventory. So if you have a house, we'll list the house, car, bank accounts, and that gets listed on this inventory. People mistake that for funding, and they believe if it's written on Schedule A, which is attached to the back of the trust, that must mean it's in the trust. It does not. Don't make that mistake. In fact, if you do make that mistake and you die, your trust is going to have to go into probate, because the property that's listed on that schedule, if it's not properly, completely transferred to the trust, it's not in the trust. And we have to get a court order in probate to put it in the trust. Example, the guy that's asking the question, guy, so the girl that's asking the question, my property's listed in my trust. That means it's probably on Schedule A. But the title wasn't changed. It has to be changed. And so the answer to your question, if you're listening, is you have to do a deed. And what you can do is a quit, not quick like fast, but quit like I give up. A quit is a transfer from one person. I am quitting my interest. So it's called a quit claim deed. That's how you can fund a trust. Some people always like to use grant deeds. Grant deed, quit claim deed. There are going to be documents that will transfer that asset, the title to that asset now will go into your trust. Now, it doesn't go into the trust. It goes to the trustee of the trust. Okay. Example. I have a trust, Gary and Cheryl Quackenbush Trust 2021. No, 2001. So 2001, our trust says the Gary and Cheryl Quackenbush Family Trust. If I want to get my house into my trust, it doesn't get transferred into the Gary and Cheryl Quackenbush Family Trust. The deed does not say that. The deed says that it is in the name of Gary and Cheryl Quackenbush, trustees of the Gary and Cheryl Quackenbush Family Trust, dated November 2001. Okay, so it's a matter of it's always titled to the name of a human being. And I've seen people, and I'm offering to review your trust and make sure your funding is right. 855-500 trust. You got to get on my calendar and you can come in and we'll look at it. 855-500 trust. What you're doing is you're trying to make sure that the house, if you look at your house deed and the deed says it went from you to your trust, like Gary Quackenbush transfers it to the Gary and Cheryl Quackenbush Family Trust, that's wrong. That's not even a valid transfer, because that trust doesn't do anything. It's the trustee that holds the property, and the trustee is under the requirement to follow the terms of that written trust. That's why we have a trust. That's why there's a trustee. You know, the trust doesn't own anything. It's inanimate. It can't. So it can hold stuff, but it can't own it. All right. Next question. Let's see. This is a how, let's see. Oh, some of these are a little bit more difficult. I'm sorry. But here's the question is, can a house be mine eventually? So if so, I would like to know how to get it back from the people that my uncle sold it to that live in it. Okay, so that's kind of the big question. Is it, can I get this house back? Uncle sold it. That's wild. So if uncle sold the property and now she wants to get it back, this person wants to get it back from her uncle. If he bought it in an arm's length transaction, like he thought it was like totally legitimate, and he did it through like with an escrow company and all that stuff, you won't get it back because that's arm's length, that he didn't have any idea. If your uncle had something to do with it, like it was a tricky thing, or they're trying to like, you know, trick you out of your inheritance or something like that, that's a different story. But to get it back from the people that your uncle sold it to, likely, bad news is that likely those people didn't have any idea what was going on. Does that make sense? They didn't know what was going on. So it wasn't like they're complicit or they're in on, you know, kind of in on this thing. They didn't know what was going on. And I'm seeing some other details that the uncle was the executor and there's no will and all that. But if the property was sold, even if it was sold for like super low value, the buyers, if they're a legitimate buyer, they got a smoking deal. That's not their fault. That's not fraud on their part. They just got a good deal. It's going to be up to your uncle that sold it for less than fair market value. You have to go after him. So that's going to be basically, you're not going to get the house back as far as I can tell. You probably are going to be in a lawsuit against your uncle for ripping you off. So there's your answer to that one. Sorry about that. That's going to take some litigation. These are things we deal with quite a bit at GQ Law. If you want help with this, that's why I'm doing this radio show. Help you guys understand that we can handle this kind of stuff. 855-500 trust. We've got a litigation team that does the litigation stuff on these, the lawsuits if we need to. We got probate court jurisdiction here in San Diego. So there's a lot of stuff we can do to help you out. If we, you know, if we need to get into litigation, we can certainly do that. If we can do it by settlement, that's our preferred method. Most successor trustees have no idea what their job is. They do what they can and they don't know how to do it legally and legitimately. That's our job, is to help you out. That's why we're doing the show, to help you understand. To be a good successor trustee, there's certain things you need to do it right. And that's just important, because if you don't do it right, then you get in trouble. Getting in trouble costs you money, and money given up is bad. We'll have Anthony tell you that on Thursday. This is Gary Quackenbush. Coming up next, talk a little bit about some different trusts. Like, what are these different trusts that are available right here on The Word on Wealth?
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
Gary,
You still going to be pumping the wattage into your cottage tonight?
Not alone. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's GQlaw.com, 855-500.
Gary is live.
Hey, welcome to the Word on Wealth. This is Gary Quackenbush. I'm so happy to be with you every weekday. That's right. Every weekday, Monday through Friday from 2 to 3. And you can, if you really miss me, you can go onto my YouTube channel, which is at Gary Quackenbush or at GQ Law, and you can find these radio shows online, which is kind of
And for those that
interesting.
really can't get enough Gary, you can tune to The Answer San Diego at 7 p.m. tonight, because he will be on with the fabulous Andrea Kay.
That's right. Oh my gosh. I always think to me, that's like, wow, I can't believe I actually do that, because she's incredible. I
You're a
know,
big newsmaker, man. She's got to
Well,
have you on.
I know. It's really fun. I still kind of are going, I can't believe I'm going to be on the show with Andrea Kay tonight. She's incredible. I love her show, and her attitude about things is just really, really, really good stuff. So I'm privileged to be on the Andrea Kay show tonight at 7. So that'll be a lot of fun. We're going to talk about some fun stuff, some scary stuff. It's always the news you can use, not just the news. So that's where I'm going to be on the show talking a little bit about picking successor trustees, coincidentally. All right. So one thing I do want to go over, we're going to be together on the up till the top of the hour. If you have a question for me, feel free to call 855. No, how about 888-344-1170? 888-344-1170. If you've ever been curious, you wanted to ask a question on air live to know what get a question answered, you can do it. It's 888-344-1170. That's the studio line. Noah answers. He can ask a question and put it out on the air, or you can talk to me directly, which is even more fun. The other thing is, if you do have a legal question for me that you'd like me to address on the air, I'm thrilled to do that as well. That way we can have more of this interaction, at least with email that I've been having. And that is, you can just email me at my, what's the easiest way? You could do it to wordonwealth@gmail.com. So it's just wordonwealth, one polysyllabic word, wordonwealth@gmail.com. And just like, hey, Gary, got a question. Or go to my website, gqlaw.com, and submit it there. So I'd love to answer your questions. And to do that, I'm going to do some more of that on Thursday. But today I want to finish up and talk about some different types of trusts. The terminology that we use as estate planning professionals, I think sometimes it gets confusing. I don't believe it's 100% intentionally confusing, although sometimes it's hard to believe that it's not intentionally confusing. It's like, are these people trying to be confusing when they come up with all these terms? I don't think so. I just think people like acronyms, and they like terms, and they like buzzwords, and then it's like giving names to things. So what you have is different shapes and sizes of trusts. So a family trust is not a one-size-fits-all situation. When I'm doing the interview with you to find out about your estate plan, and this is whether I'm reviewing it or not to see if it's all good to go, or if you want to make some changes, or whether we're doing a brand new setup, which, like, I love all that, is we will talk about your stuff. What do you have in real property if you have a house? What about rentals or investments, and how are they held? Is it retirement accounts or just straight up investments, and things like that. So we'll talk about all of that when you come in for your trust review or your estate planning consultation. So trust that we've heard of before is an AB trust. Well, let's talk about first, what about a living trust? A living trust is the same as a family trust. That's the same as a revocable trust. Okay, they're used synonymously. We just call them living trust, revocable trust, family trust. We call them grantor trusts, settlors trusts. They're different. They're all the same thing. They literally are just different titles, because the person that creates a living trust is called a settlor, because what they actually do is they don't create the trust, they settle it. So they're a settlor. Because it's their trust that they created, they're the ones that made the orders, and they're the boss. So that's why it's called the trust or the grantor. So it's a grantor's trust or a trustor's trust. And living trust, I always just like to use living trust, because living trust means it's living. You created it while you're alive. It's a living document. It can be amended until you die or become incapacitated, and then it stops being amendable, changeable. It becomes irrevocable. All right. So regular trust, living trust, all that. Now, there are different types of them. There's this thing called an AB trust. They happen, we used to do a lot of them before 2010. The law changed in 2010. That was like 12 years ago. So come on, you don't need an AB trust unless you do. Now, if you do, when you do need an AB trust, like blended family, mom and dad or husband and wife have children from different relationships or different marriages, that's going to require an AB trust, because the distributions are going to happen based on deaths. When it's the mom and dad are married and they've got all the children and stuff, and that's all like, kind of a conventional, traditional family. When mom dies, dad owns it all. When dad dies, mom owns it all. And until mom dies, the kids don't get their share, which is totally normal. Now, when you have a blended family where dad has his own kids and mom may or may not have her own kids, and maybe they have kids together, there's going to be a difference on how you want things done, because dad's kids have a different mom. So there may be money coming from that side of the family. So they don't need money from the new spouse, right? So that's where you're trying to figure out how to be fair. The only way to get that done is to do a trust. You can't just hope it. You can't do emails. You can't do a holographic will to get all that done. It's got to be a living trust. And when you do a living trust and it's a blended family like that, you should really consider getting an AB trust. And that means that the trust splits at the first death. So as soon as one person dies, there are certain legal things that happen with a trust. Part of the trust might be sealed and become unchangeable, and part of the trust might stay changeable, unsealed. All right. So sealed, unsealed. That's kind of what's going to happen. Irrevocable, revocable. It's not always an AB. That's just the first two letters of the alphabet. It could be ABC, ABCD. You get kind of alphabet soup on the different trusts that can be created. So that's the AB. We used to do it because we needed to transfer huge amounts of property. We're trying to double the exemption. We don't even need to do that anymore. In fact, it's not even available. So AB trusts now are typically going to be for blended families, or if you're trying to protect an asset, husband has a bunch of stuff and like prenuptial stuff, that's the other kind of thing. AB trusts, there's some failures that happen with them. And that is a lot of times when there's an AB trust with very specific instructions and the first spouse dies, the second spouse never sets up the A and the B. They just keep the A trust. Well, that's not a good thing if the AB trust was designed to protect the decedent's children. So if the trust says when husband dies, then, his children get, the rental property and everything else stays with the wife, then the kids get that rental property. So if the wife decides, husband dies and she ignores the fact that there is an AB trust, never transfers the house to the kids, who's damaged? Well, his kids are getting ripped off, and that wasn't the intention. So don't do that, because then you, as the surviving spouse, now inheriting the property and refusing to give the right amount of money to your stepkids, that's a bad thing. That's actually a really bad thing. It's kind of like fraud. So don't do that. I mean, you got to do what the trust says. All right. So AB trusts, sometimes they get some tricky issues, but I think they're a lot of fun. Then there are trusts for blended families, a little bit different, and that is a Q-tip. So this would be, for example, mom owns a house, or we'll say wife. So wife owns a house, husband and wife get married. They each have their own children. But the house is owned by the wife. And they want, if the wife dies first, we want to be able to leave husband in the house. So we do a Q-tip trust, QTIP, like the thing you stick in your ear, not too deeply, but it's a QTIP, Qualified Terminable Interest Property Trust. And the idea of that trust is it makes it so the house is still available in trust, supervised, managed, and watched over by the remainder beneficiaries, which would be probably her kids, but at least he gets a home to stay in. Now, I've done them where it says that person can stay in the trust as long as they keep, they have to pay all the expenses, utilities. If there's a mortgage, they got to do repairs, keep it up to date. It has to be up to speed, keep it up to speed with the rest of the neighborhood, so that's not being all run down and stuff like that. That's a requirement. Then if he gets remarried, he's out. If somebody moves in, he gets a girlfriend that moves in, he's out. If he moves out of the house to another place and doesn't use the house anymore, we sell it and distribute the money. So that's what the Q-tip is. It's this temporary place. I've had ones where we wrote in 5 years. So it was when husband died, wife could live in the house for 5 years. She had family money, so it wasn't a big deal, but she had 5 years to kind of wrap things up and move out. So things are fair, unfair, doesn't matter. That's the way it works. So that's Q-tip trust. You have other trusts like for special needs. If you have a beneficiary that's on government assistance, maybe, goes to the community center or has maybe Medi-Cal or Medicaid or something like that, you've got to do special needs trust for them. Any of this stuff we can help you with. This is all good stuff. I love this kind of stuff. That's why we're doing the show and talking about it. 855-500 trust is my number if you want to talk about setting up a Q-tip trust, special needs trust, AB trust, spendthrift, a gift trust, asset protection trust, irrevocable life insurance trust. Those are all different things that we can work on. Tell you how they work. Is it for you or not? Is it a good idea or not? How long does it take? What does it cost? What's your commitment to get it done? Happy to do that. 855-500 trust. All right. Rest of the week. Tomorrow, John Burroughs, mortgages. We're going to be talking to John about housing, mortgages, the interest rates, what's going on, buy, sell, first-time home buyers. Really good stuff with John Burroughs. On Thursday, we've got Anthony Wright talking about all things money. And on Friday, we have Matt Quackenbush, trauma therapist, talk to us about some good stuff right here on the Word on Wealth. See you tomorrow, everybody.
Tell a friend about the Word on Wealth, featured since 1995 with financial solutions
Good show. Good show.
and tax problem solving. Gary is past president of the California Society of
Yeah. So I'll just assume we're doing it by phone. If you do want to test up the home setup, just let me know.